Hi, I'm Elizabeth Gearhart. I'm sitting here with Richard Gearhart, founder and owner of Gearhart Law. And Gearhart Law is doing a lot of litigation these days.
We are. And we wanted to talk a little bit about litigation and what the litigation process is like. And so it's very complicated, involves a lot of different elements that we won't be discussing today, things like jurisdiction and venue, which courts you select to file the lawsuit in, who are the proper plaintiffs. All of those are complicated legal issues that you need to go into when you start a case. But what we're going to do is just talk about some of the basic documents that get filed in a case. And we think it's important that our clients know that we are experienced in litigation, because if they ever need for us to file a case on their behalf, they know that they're in good hands. And secondly, all of the planning that goes into preparing a patent or trademark application and the process of obtaining that patent and trademark is done against the background of litigation. So you never really know what's going to happen to that patent, but if it ever gets litigated, you want to make sure that it's written in a way that's going to be as favorable for the client as possible if it ever ends up in court. And so hiring a firm that has that background and that experience makes for a better piece of intellectual property, whether it's a patent or a trademark. So usually the litigation process starts with a cease and desist letter. Somebody sends somebody a letter claiming that they're infringing their intellectual property. If the parties can't agree on resolving it at that stage, then oftentimes a complaint is filed. Since the intellectual property is based in federal law, the federal courts have jurisdiction over patent and trademark and copyright matters, which is important because federal courts are, should we say, a little bit more sophisticated than state courts, and the decorum is different.
So you can file in federal district court anywhere, but then if you actually go to court, I guess, do you file in your own state? Do you file in federal district court, say in New Jersey, or federal district court in New York, or?
Well, it's very complicated because there's the complaint can be either filed where the defendant resides or the plaintiff resides or where the products are being sold. All of those approaches have their strengths and their weaknesses. Usually a case is filed where the plaintiff resides. That's the most common, but you could also file where the defendant is located or where the product is sold.
Okay, so then you file the complaint with the court. So you've tried the cease and desist letter. You couldn't get them to stop misbehaving. So then you file the complaint with the court. So,
Right, they're infringers.
They're infringers. So in this case, we live in New Jersey. So you would, if it was one of your clients who was filing the complaint, you would probably do it in federal district court in New Jersey.
Right. There's a likelihood there. And part of the reason for doing that is that if it's a New Jersey company, it's more convenient because to go to the hearings and do all the legal stuff that needs to be done. It's easier if the client is in New Jersey rather than filing a complaint in California, which adds to the expense of the litigation because then the lawyers would have to travel to California, and so it just becomes more expensive. So one of the big reasons for filing locally is the cost savings to the client.
So then you file the complaint, and then what happens?
Well, then the defendant has a certain specified period to file an answer, right? And after that answer is filed, there's usually a pretrial conference with the judge where they discuss discovery. And so discovery is the process where the opposing party asks for all of the documents. Well, they start with interrogatories and they ask questions, and then after the written questions, they ask for document production, which means that you have to turn over all of your documents that are related to the case. And so this is why it's important that when you're drafting a patent application, you act ethically and make sure that all of the proper information that needs to be put in the application is put in the application. Things like inventorship are right, because if you ever go to enforce your patent, all of the documents related to the patent are going to be given to the other side.
Even emails?
Even emails, anything that's not privileged by counsel. And in addition, the inventors are going to be questioned by the opposing side if it's a patent, or the trademark owners. So the other side is going to have opportunities after reviewing the documents to ask all of the interested people questions during depositions, which are recorded. And so they're recorded and transcribed by a court reporter. So a complete transcript of the deposition is made. And then the lawyers can look at the deposition and look for inconsistencies, inaccurate statements, and then those statements are typically used against the other party during the litigation process.
If you have to depose somebody that is, like, let's say they flew to France or something, and they're not coming back for a while, do you have to go to France to do it? Can you do it through Zoom? Or do they have to come here, or how does that work?
It depends. They can be subpoenaed. They can be asked to come to the United States. They can come voluntarily. If they reside overseas, then you have to serve them through what's known as the Hague Convention, which is an international convention that allows for the serving of witnesses. It takes anywhere from 18 months to 2 years to serve a subpoena on somebody who's overseas. If they don't appear voluntarily, then it can be a long, arduous process to get the deposition, and then you have to travel there. And different countries have laws that are more or less cooperative with that process, because many countries don't like their citizens to be subject to foreign lawsuits. So it's best to get them in the U.S. if you can.
But they can't get away necessarily by moving away or going to another country. You can still track them down.
Yeah, if your client has the budget to go through that process. The main point I think that's so important is that everything we do during the patent preparation process, the trademark preparation process, is all geared to protect your interests should a litigation ever occur. And so when it comes to disclosing certain things, making sure the right information is there, we're doing it because we want your patent or trademark to be valuable if you ever have to enforce it in court. So we try as best we can to work with our clients to make sure that in the long run, their stuff holds up if it's ever put to the test.
Right. And so you have the experience of having gone through litigations, and you know what the court looks at, what it's looking for. So you can use that experience from the very beginning of the project.
Exactly.
And I think that's important, because you don't really know that stuff unless you've been through it.
I think that it certainly helps a lot. I mean, there are attorneys who haven't been through the process and they sort of know the rules, but I think if you've been through the process, it gives you a deeper appreciation. And it reminds me of Stephen Covey, the famous author, who says, begin with the end in mind. So the end in this case is a successful victory or enforcement of your intellectual property, and we begin with that goal in mind.
Thank you. How many litigations do you have right now going on?
More than enough.
Enough to keep you busy all weekend, every weekend, I should know. So anyway, well, this is Richard Gearhart, founder and owner of Gearhart Law. And how do people find you?
You can find us on our website. It's gearhartlaw.com, GearhartLaw.com, or you can call us 908-273-0700. Always happy to hear from you and talk about your IP projects.